Hey guys, I'm gonna have to make this one a little bit quick because I'm on just a short break from work, and then also right after I clock out, I have another thing I have to be working on. So we'll go through this really fast. It's only like 3 or 4 pages of a letter. There is a declaration that went with it, but pretty much everything of substance is under seal, so we won't look at that. So this is, the conflict over the motion for judgment on the pleadings. Wayfarer filed that motion, I think it was last week. They're basically saying that assuming the factual allegations are true, that Blake's, claims still fail as a matter of law. That's the best way I know how to explain it, but definitely talk to somebody who's actually a lawyer just to verify that. But I am going to run through this really quickly. This is their reply after she filed a letter trying to dismiss that. Hers didn't really make a lot of great arguments, I thought. She was basically saying it would delay the trial at this point, which doesn't seem to be true. She was saying that they waited too long and they sat on it, and it seems like that's not true either. Like, you can wait until a more advanced stage of all of this stuff to file one of these. So that was kind of stupid too. So yeah, they're going to address her arguments regarding that letter. So it wasn't actually a response to their motion. She was asking the judge to either dismiss their motion entirely without prejudice to be addressed later in the judgment, like the summary judgment stage, which this is different than a motion for summary judgment. So that didn't really make a lot of sense. Or she wanted an extension of basically she would have a month to reply, and she wanted her deadline extended to October, I think it was 27th. But we're going to read this here. Maybe it'll remind us. But it's just, I don't know. A lot of it was seemingly very confusing because, like, my dilemma is always that I'm not a lawyer, so I can't tell when something sounds really stupid if I'm just like not understanding something. But with this, when I listened to all the law tubers who talk about it, it sounded like a lot of what she was trying to argue for did not make sense. So we're just going to run through this really quickly. By the way, there is a hearing over this matter tomorrow that is going to be publicly available. Let's see, what time was that at? It's 2 p.m. Eastern. Tomorrow, October 3rd. Yeah. So I'll put the teleconference line and the access code in the comments of this video after the live stream is over. Not the live chat, but the actual comments, so I can pin it, and you'll know how to access it. So this is what they're going to be addressing tomorrow. All right. Rule 12C permits a party to move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. Okay. A challenge to plaintiff's failure to state a claim is not waived until the close of trial. Right? So there is no hard and fast time limit on Rule 12C motion. Okay. Ms. Lively erroneously argues that the Wayfarer parties sat on their motion for nearly 9 months, and that adjudicating the motion now would only lead to duplicative briefing and waste judicial resources. First, Ms. Lively's operative pleading was not filed 9 months ago, but 2 months ago. And that's true because she had the second amended complaint after Jed Wallace was dismissed from the lawsuit without prejudice. She filed the second amended complaint, I think, at the end of July. Yeah, they got it right here. It's July 30th. Okay. In response to the court's dismissal of her claims against Jed Wallace and Street Relations, Ms. Lively was not obligated to amend her pleadings, but nonetheless chose to file her second amended complaint on July 30th. When Ms. Lively opted to supersede her earlier pleadings with the filing of the second amended complaint on July 30th, she knew that the Wayfarer parties were not obligated to file answers thereto for several weeks thereafter, and that upon such filing, and only upon such filing, the Wayfarer parties were entitled to move for a judgment on her pleadings. And I think they responded sometime in like early to mid-August. They remember whenever she did her complaints, her amended complaints, second amended complaint, they never did a motion to dismiss or anything like that. They always just responded. And then this kind of makes sense because when you look back to March, when they were talking about motions to dismiss, and when Blake was filing her motions to dismiss, Brian Friedman came out and basically said, we can see the deficiencies in their complaint. We're not going to file a motion to dismiss because we're not going to map out for them what they should do to fix their claims, basically. So they just answered her claims as they were, and then they plan to eventually do this. All right. Indeed, as Ms. Lively recognizes, at a July 30th hearing and a related proceeding, the Wayfarer parties notified the court that they may seek relief under Rule 12C. If Miss Lively is now unprepared to oppose the motion, the fault lies with her. And she was complaining that there were, a bunch of depositions to still be done before her deadline to respond to this would have been. And that's tough shit, Cupcake. So, I mean, it's not like she doesn't have enough lawyers working for her. They have known the deadlines this whole time. It's not really anyone else's problem. Or at least it shouldn't be. Do I think the judge will give her an extension? Yes, I do. I'm sorry. I think she always gets what she wants. And I'm not saying, guys, I'm not really on the train of the judge is bought by Hollywood or anything like that. I respect everyone's opinions. You guys are always welcome to express that as long as you do so respectfully. But I'm not one of those people. That being said, I see the pattern, and I very much feel like she will get an extension. Do I think she should have one? No, but that's just me. All right. Second, the motion will reduce briefing on any subsequent dispositive motion and preserve judicial resources. In contending that the question at this stage of the case is not what the pleadings allege, but what the evidence shows, Ms. Lively misconstrues the standard of review on a 12C motion. A judgment on the pleadings is appropriate where, with all reasonable inferences drawn in favor of the non-moving party, the non-moving party has failed to allege facts that would give rise to a plausible claim or defense. Here, the motion seeks dismissal based upon purely or predominantly legal issues. 1, Ms. Lively's claims for sexual harassment, retaliation, failure to supervise, and aiding and abetting under California statutes fail for lack of extraterritorial application. And remember, the extraterritorial stuff is also something that came up in their response to the 47.1 motion. This is a separate thing entirely. And I think that was confusing some people last time. But they're making this argument in 2 separate motions. One was only dealing with the 47.1 motion where she's seeking treble damages and all that. This is something else entirely. They're trying to dismiss her claims or get a summary judgment on her claims. Okay. No, not a summary judgment. What is it called? Judgment on the pleadings? God, these things confuse me, man. It's a lot of words that sound the same, and I'm learning. All right. Ms. Lively failed to exhaust her administrative remedies with respect to various claims against It Ends With Us movie. Ms. Lively failed to adequately allege retaliation. Ms. Lively's defamation claims are barred by the litigation and/or fair reporting privileges, something that she knows very well. She knows that. She definitely used that to her advantage. But then here and in the 47.1 motion, she's trying to argue that that shouldn't apply to them. Oh, no, it shouldn't apply to them, just to her. Okay. 5, Ms. Lively failed to allege an underlying tort supporting her civil conspiracy claim. None of those issues require the court to examine anything other than Ms. Lively's second amended complaint and the materials incorporated therein by reference or integral thereto. Tellingly, Ms. Lively does not specify how any of the voluminous evidence she has uncovered would be properly considered in opposition to the motion or warrant the denial thereof. So remember, she said vaguely, she's uncovered all this evidence to support her claims now through discovery. And I would call bullshit on that because when she was writing her 47.1 motion, the only evidence she could come up with to support her position was that a person unrelated to the film or unrelated to this project at all, unrelated to this lawsuit, had a general negative experience with Justin Baldoni on a different project. Nothing to do with sexual harassment. Okay. So Miss Lively's voluminous evidence, I don't know, guys. Maybe it's all in the tag disclosures with all the names of the content creators that totally conspired with Brian Friedman, right? Okay. All right. Stated differently, there is no need for Ms. Lively to scramble to amass evidence from ongoing discovery to oppose the motion because the motion challenges defects on the face of her own pleadings. So they're not looking at evidence so much. They're not looking at that. They're assuming that even if the factual allegations were true, her arguments would still fail based on the law. Although Ms. Lively notes that she may yet again amend her pleadings, she does not explain why she has or not done so, or why the court should allow any such amendment at this stage of the litigation. If the motion is granted in full or in part, any such adjudication will reduce the number of Ms. Lively's claims. In turn, and even assuming any party subsequently seeks summary judgment, the case will have been properly streamlined, thereby reducing the amount of briefing. I am going to sneeze. All right, sorry about that. Reducing the amount of briefing on any such motion. Thus, judicial resources will be preserved. Okay. Third, Ms. Lively does not and cannot explain how the adjudication of the motion will delay the trial scheduled to commence on March 9th. Fact discovery is ongoing, no summary judgment motions have been filed, and the trial is more than 5 months away. This is why I was like, this doesn't make sense to me when she was saying, it was going to delay the trial. I'm like, what are you even talking about? Courts have granted Rule 12c motions at procedural stages that are much more advanced than in this case. Okay. We're just skim down to this part here. Ms. Lively's request for an extension of time to oppose the motion should be denied. In the alternative to her request for dismissal of the motion, Ms. Lively asks for an extension of time from October 10th to October 27th to formally oppose the motion. Ms. Lively seeks the extension for the reasons given above, which appears to be that discovery is ongoing. The court may recall that, while discovery was ongoing, the Wayfarer parties were compelled to oppose dispositive motions, as well as numerous motions for sanctions against the Wayfarer parties and their counsel, filed by Ms. Lively and her husband, Ryan Reynolds. Yeah. So while all that was ongoing, she was bombarding them with the Rule 11 sanctions motions and all that, and the motion against Brian Friedman specifically. She was doing all kinds of crazy shit. Additionally, granting Ms. Lively's request would mean that the parties would be briefing the motion close in time to the summary judgment deadline before the court has had a chance to narrow the case. The request should be denied, and that makes sense to me. Okay. All right. The court should amend the case management plan and scheduling order. On September 9th, the court revised the expert discovery schedule to provide for the completion of such discovery by November 14th. However, the parties did not propose, and the court did not endorse, an adjournment of the current November 5th deadline for summary judgment motions. As it stands, summary judgment motions are due before expert discovery may be completed. Accordingly, and given that certain fact discovery has not yet been completed, but is expected to be completed by October 10th, last night the Wayfarer parties proposed the following revisions and are awaiting a response from Ms. Lively. Okay, so October 24th, deadline to exchange opening expert reports, expert rebuttals, okay. December 1st, deadline to complete deposition of experts, and December 15th would be the deadline to file summary judgment motions. So they've pushed that back like a month, right? All right. Good cause exists to amend the scheduling order. The proposed schedule will provide the court with sufficient time to resolve the motion, give the parties the opportunity to finish fact discovery prior to exchanging opening expert reports, and allow the parties to complete expert discovery prior to the filing of summary judgment motions. Most importantly, if the majority of Ms. Lively's claims are dismissed via the motion, the proposed schedule will allow the parties and the court to focus on her few remaining claims in connection with any summary judgment motions and/or trial. Okay. On September 30th, 10 days before the current October 10th deadline for opening expert reports, Ms. Lively proffered a new theory of damages, whereas Ms. Lively's alleged lost profits computation was previously based upon, and that's part of the sealed stuff in the deck. She has recently added, and then again, that's sealed, the Wayfarer party's expert must now examine that claim. Okay, this is regarding a different request that she made. The request to extend the deadline for requests to admit should be denied. On February 3rd, the court directed in the case management plan and scheduling order that requests to admit shall be served by August 14th. In the parties' joint request to revise part of the scheduling order, no request was made to extend that deadline and no extension was ordered. Now, 8 months after learning the deadline and 6 weeks after the deadline has passed, Ms. Lively seeks to extend the expired deadline. I mean, that's not just like a little bit past, like it's long expired. However, Ms. Lively fails to explain why she did not serve requests to admit by the deadline or why the existence of future depositions prevented her from serving requests, especially given that the purpose of requests to admit is to narrow factual issues. The request should be denied for failure to demonstrate good cause for the proposed amendment. All right, guys. Hey, man. Hey, Omar. I heard she hasn't been paying the bill. Oh, man. I thought more about it than Lively's motion to dismiss. What does that mean? Her not paying the bill? Okay, so I got to get back to work, guys, but that's really all there was to it. So, like I said, I'll put the what is it called? The teleconference line and the access code for tomorrow's hearing in the comments of this video, not the live chat. It'll be pinned in the comments here, so you can come back here to find it. It's tomorrow at 2 p.m., and I'll be talking about all the stuff that we just read over. So, all right, thanks, everybody. I will talk to you soon.